Earlier this week, Google faced a major setback in its efforts to create the largest digital library of books. And now the search giant is facing antitrust inquiries from attorneys general in Ohio and Wisconsin on top of those anti-competitive investigations by the European Commission. To help shed some light on these cases, we are joined by one of Google's top antitrust attorneys, Jonathan Jacobson, who is a partner at Wilson, Sonsini, Goodrich, and Rosati. I hope I pronounced all those names correctly.
Perfectly well. Thanks, Betty.
John, thank you for joining us. First off, have you received any inquiries or questions from the AG offices in Ohio and Wisconsin?
I'm not familiar with those. So, Microsoft has been very active in trying to commence investigations against this. So it wouldn't surprise me, but I have no information
that they prompted these investigations.
I have no information of anything concerning Ohio or Wisconsin. It's the first I heard about it this morning.
Okay. So, but are you doing any work on the case in Texas, for instance?
Our firm is helping respond to what's not a case. It's simply a civil investigative demand from the Texas Attorney General.
Okay.
And our firm is indeed helping Google respond to the questions the Texas AG is posing.
And what questions are they? What are the nature of their questions to Google?
The scope of the inquiry is up to them, of course, but
sure.
I do think they're looking into the type of algorithmic search paradigms that Google has, the extent to which some sites, by virtue of the algorithm, do not show up as highly in the search results, or their ads are not displayed. And I think that is one of the things that the Texas Attorney General is looking into. That's also the scope of the European investigation.
Right, exactly. I was going to say that's related to what the EC is looking at.
Yes.
So as the attorney representing Google, then, how do you counter what is essentially these accusations that Google is using its dominant position in search to basically restrict competition among other advertisers or other search engines and to use it to get more preferential treatment for its own services? How do you counter that then?
All right, well, there's simply no truth to the fact that Google is preferring its own services. Google.
How do you say that?
Because there's simply no suggestion to that effect. Google has Google Checkout, for example, a payment service. Google does not prefer that in any shape, manner, or form. When Google displays video results, it displays those from YouTube, but also other video sites. In terms of maps, Google does display the best maps, which tend to be Google Maps, but MapQuest displays are also appear in Google search results. It's simply not true. Secondly, what Google does in the search business is free. All right, you don't really pay a lot for a Google search. You pay nothing. So the only way Google can be successful in search is to have a better quality product. Everything that Google does, everything that Google is being looked at for doing is designed to enhance the quality of search. Google search is used more than other search engines because it's better. If for some reason
it has a 65% share of the market, I think, right?
And that's consumers voting with their feet. They're not being charged for the service. They're not being charged for Bing either.
But clearly, though, I mean, what the regulators are looking at ahead is, let's say, Google's acquisition of ITA. I think it's a $700 million acquisition. What they're saying is that could eventually turn, though, into an anti-competitive practice because Google will then prefer its own travel sites to Expedia or others.
And as I said, there's no historic evidence of that.
There's no historic evidence because that hasn't happened yet. But that's the issue is that going to happen?
Well, I think you have to look at other areas like Google Checkout, payments, other areas of vertical search, and there's simply no evidence that Google is favoring its own products. And if Google favored its own products in a manner that generated inferior search results, the beneficiary of that would be who? It would be Yahoo, it would be Bing, because Google search would not be as effective. So consumers, again, would vote with their feet and they would go to other search engines. One has to ask why is Microsoft behind all of these investigations? Does Microsoft have an interest in doing anything other than degrading the quality of Google search? No.
No, but I mean, behind every antitrust investigation is your rival. I mean, you know that with Coke and Pepsi and with Microsoft and Netscape. You know all of that, of course. But let me just ask you this.
Well, but there's an important point to be made, which is that antitrust is about the beneficiary of consumers. Antitrust is there so that consumers get the best benefit of the bargain available. If Microsoft is out there trying to degrade the quality of Google search, do consumers benefit from that? No, they don't. Bing does, but consumers do not.
Microsoft, of course, would argue that they're not degrading the quality of the search. But, however, let me just ask you quickly about this digital, this online book library that, there was that setback earlier this week that Judge Denny Chin said, look, that he rejected this settlement, right? So what are the options right now for Google legally?
Well, Google can continue with the litigation. It was simply a settlement that the judge has not approved. Google can try to recast the settlement with the book publishers and the authors to meet the objections that Judge Chin voiced. Google could ask Judge Chin for permission to appeal his ruling to the Court of Appeals. Or, as I said, just simply continue with the litigation. Google's basic position is that the scanning and limited access through Google Book Search to the books that it has done over the last couple of years is simply fair use and entirely permissible under the copyright laws.
Right.
So the effect of rejection of the settlement is not going to change the status quo. It is going to deprive consumers of the huge benefits that the settlement would have generated.
Right, of books that have been basically not available online to be online because Google would scan them in. But okay, of those three options, I've got to run, but of those three options, what is the most likely that Google is going to exercise?
I'm not able to comment on that at this time.
All right, John. Well, when the time comes, we'd love to have you back on to talk more about it.
Be a pleasure, Betty.
Appreciate you stopping by. John Jacobson, one of Google's top antitrust lawyers.